I was defending a person charged with all of the things that I believed in.
Yeah.
So it taught me not to rush to judgment. There is a sense now that powerful people need to be on their toes and use that power appropriately. Everybody has a different style. Everybody has a different voice. Everybody has a different approach. And it's really important to develop your own voice.
Welcome back to another episode of Courtside Convo. I'm Dan Dosky from Legal Graphic Works, and really pleased to have with me today Tama Kudman. She's from the firm of Kudman, Tracton, Allo, and Posner. Tama, welcome to the show.
Thank you so much for having me.
So first of all, what made you want to become an attorney? And also tell us about the practice, about the firm, and what you guys do.
Sure. So it's sort of a long story. My father was born in Poland before World War II. And when I was growing up, he told me about growing up listening to the radio for survivors of the Holocaust. And of course, there were none. My whole family was killed in Europe. And my father, as a result of that, was incredibly passionate about our country, about the Constitution, and about the concept of due process. And so I grew up in a household where we were constantly talking about the rule of law, about democracy and how essential it is, and how essential our courts and our court system is to due process and to keeping our Constitution real and thriving. And so I really had no choice but to become a criminal defense lawyer. I was literally bred to do this.
Right.
So here I am.
Yeah. So how did that lead to the firm, and what do you guys do for your clients? Do you have a specific focus?
So I was not the only one indoctrinated by my father. My older brother, who's 14 years older than me, is the managing partner and one of the two founding partners of our firm. And when I was in law school, I worked for the firm. And then when I graduated, of course, I was doing criminal defense, and they are predominantly commercial, transactional, and litigation firm, right?
Yeah.
And it never seemed to be the right fit for me. Plus, I didn't want to be the kid sister working in my big brother's firm.
Right.
So I went off, and as you know, I've had this wonderful career in criminal defense. And the firm approached me and said, look, we want to have a thriving white-collar criminal defense and regular criminal defense practice as part of our firm offerings, and we want you to head it.
That's amazing.
And it's going home,
Yeah.
right? I grew up in the firm, and now I'm back there, and so I'm home, and it's wonderful. We do everything from commercial litigation to transactions to bankruptcy to real estate to
Right.
you name it, we do it. But my part of the practice is, of course, criminal. So
Yeah. So let's get into that. So what do people need to understand about a criminal defense attorney, and specifically, what you do in white collar?
So everybody jokes, I'm the lawyer that nobody wants to ever have to call.
Right.
But the reality is that it's more than just when you're being arrested that you need a criminal defense lawyer. Businesses need due diligence done and internal investigations often to make sure that they're being compliant. So, a little bit of healthy self-examination can prevent one from becoming a target of an investigation, or to help a company or an individual when they're being investigated to find their way through it. Criminal defense encompasses all of that. And I have clients who never become prosecuted or even investigated because they've run, for example, healthcare company that wants to make sure that it's being compliant and they have specific concerns. I'll work with, for example, our healthcare lawyers to ensure that any of their concerns are addressed and redressed. And if necessary, sometimes we self-report so that they can avoid prosecution and sort of, nip it in the bud before it becomes a real problem. So at every stage, pre-investigation, during an investigation, and of course, once a person has been charged.
Yeah. So you do a lot of federal work.
Correct.
What happens when the government sets its sights on you?
So, there's no one path, right? And some cases happen very quickly. A person's arrested, charged, and then they go through the court system. And some clients feel very strongly that they have a defense to the charges, and we go to trial. And sometimes people feel that they understand that they've done something wrong, and they want to try to reduce their exposure by working with the government and pleading. And so there's no one path. And what I would say is to young lawyers, whenever you're working on a case, and this is across the board, not just in criminal, it's important to understand what your client's goals are.
Mm-hmm.
And it's also very important to know the facts better than anybody, better than the prosecutor, better than opposing counsel. I always tease my clients and tell them that I will know the case better than they do, in short shrift, because it's the facts that drive a case. And so it's very important to understand what your client's goals are, understand where the bombs in a case are,
Mm-hmm.
understand what the good facts are, listen to your client. They know the facts usually better than anybody. Talk to them, listen to them. Don't dismiss them. And always remember, it's not your case, it's your client's case. And so you've got to get your client to where they want to be.
Yeah.
And even if you think it's a great trial case, or you think it's a terrible trial case, you have to honor your client's wishes, have meaningful, full discussions with them, and then come to a decision together.
When somebody's up against a federal prosecution, what are they up against? There's a lot of resources that the government can bring to bear in those cases.
That is true. The government has a lot of resources. The government has a wonderful investigative team, right? They have technology. They have tons of lawyers at their disposal. But that doesn't mean that defendants are at a complete disadvantage, right? I like to think that I bring to bear all of my experience and knowledge and experts, right?
Yep. So
we also have great technology. And I will say that as technology gets better, it becomes more available, and
it's even the playing field.
Absolutely. Sure. AI, which we all know we can only utilize up to a point, right? And we have to do our due diligence and check on it. But it is a wonderful way to start investigation, to start analysis, to get a smattering of cases that we then have to investigate further and make sure they're real cases and all that other good stuff.
But you can get that lead, that idea, that spark in a few seconds, as opposed to maybe days.
Oh, right. It's another tool. Yeah. It's not the end all and be all, but it's another tool in our toolkit. So I would argue that actually technology is leveling the playing field. And I would also say that the government's success rate is daunting, right? We all hear these extraordinary success rates, but a lot of that is because people have stopped going to trial and there are a lot of pleas. But the government isn't quite as successful on the white collar front as the statistics would suggest.
Yeah.
They are very successful on sort of the street type of crimes. And of course, if you plead guilty, that's a success for the government.
Right.
What the statistics don't bear out is the success of good plea bargaining, of working out good deals with the government. Sometimes that's a win. Sometimes we can convince the government not to prosecute. There are facts or factors the government may not have considered in a charging decision, or if you can get to the government pre-charging decision and bring things to light, you can have success. And turning, I would say, a target of an investigation into a witness is a tremendous success.
Yeah. So you worked on some really high-profile cases. I know some maybe you can't talk about, some you can, but tell us of the ones that you can. Tell us about some of the cases that stand out in your career.
So I want to start by saying that for any person who's facing investigation or being charged with a crime, their case is the most important in the world. And so while I've had this career that has put me into these cases that have become very high profile or were high profile, and I've been fortunate to represent those defendants. They're all equally important. So to me, all of my cases are the most important case in the world because they certainly are for my clients.
Right.
The first really high profile case that I ever was part of was representing one of the police officers in the Abner Louima case in New York back in the late 90s.
Yeah.
I was a baby lawyer. When the case hit, we had no idea what we were walking into. We were just representing a police officer who is one of the best people, I will tell you, that I've ever met. He wound up being acquitted of all the civil rights allegations.
So the case was a while ago. Give us, like an overview. What happened in the case and why was he being charged?
So our client was a police officer in Brooklyn, and he was actually the union representative in that particular precinct. There was a fight outside of a bar that was frequented by the Haitian community in Brooklyn. And when the police responded, there was one particular gentleman by the name of Abner Louima who wound up being arrested. And one of the police officers had believed that he had sucker punched him during
the melee.
The melee that was going on. And it was really a big scene.
Right.
Mr. Louima later alleged that when he was brought to the precinct that he was sodomized in the bathroom by a handle of either a mop or some kind of a wood stick,
broom,
or whatever. Right. My client was not the officer alleged to have done that. He was alleged to have walked into the bathroom, have seen what was going on, and then when he went into the bathroom, my client, he saw only one police officer in there. And it was alleged by Mr. Louima that 2 police officers had done this to him. And so when my client went to investigators and said, look, when I went into the bathroom, there was only one, he was charged with obstruction for having lied to investigators. The belief was that he was trying to protect his partner, who was the other person charged in that bathroom. Mr. Louima later claimed that he was also beaten up during the car ride to the precinct. And that was the civil rights violation that was alleged against my client.
Gotcha.
So it was one of the first really big police brutality cases.
Yeah.
There were riots in the city about it. On our way to the courthouse every day, we were surrounded by civil rights advocates protesting the trial, protesting our clients. It was extraordinary. And of course, I was all of 27 years old, fresh out of law school. And it was interesting because I went to law school to protect civil rights.
Right.
And here was one of my first high-profile clients charged with violating a person's civil rights. And the case taught me so much because, first of all, my client was, like I said, one of the best human beings I've ever met. And there was a rush to judgment by the mayor who called all of these police officers Nazis. It was Mayor Giuliani at the time. Mm-hmm. The public was outraged, as they should be, based on the allegations. But I had a client that I knew was not guilty of what he was charged with.
Yeah.
And who was also a great person. And so it was all these contradictions of I was defending a person charged with all of the things that I believed in.
Yeah.
So it taught me not to rush to judgment. It taught me to tune out sometimes what you're hearing in the media, which brings us also to a media conversation.
Right.
Because, sometimes what you're hearing in the media is because the story is being told from one side. And defense lawyers have to decide when it's time for them to jump in and start getting their story into the public arena, right? To prevent too much prejudice.
Yeah. Yeah. So what were some of the lessons you learned, about the media in that case, and then obviously later on throughout your career about dealing with the media, using it, not using it, et cetera?
Well, first of all, when only one side is telling the narrative, sometimes that can be a terrible thing because the public's only hearing from the prosecutor's side, right? The government is telling its story. And when they're able to tell their story unchecked, a lot of untrue facts seep into the public, who is eventually going to be your jury pool.
Yeah.
Right. But at the same time, I'm not a believer in running to the media and speaking about my clients' cases. Because first of all, sometimes you learn new facts later on that change the narrative, right? And so you don't want to marry yourself to a narrative too early. Secondly, when you rush into the media and make statements, it cuts off your client's options very often. Mm-hmm. And again, I'm a big believer that it has to be the client and their wishes that drives what happens with a case.
Yeah.
Sometimes strategically, you don't want to let the prosecutor know what your plan of attack is going to be, right? And also, it in some ways, when you start telling a story out in the public, it puts a burden on your client to prove their innocence. So we have to be careful about how we use the media. And when I say use, I mean, how we choose to tell our story in the media, if at all.
Yeah.
But that's why it's very important for lawyers to work very closely with PR professionals and decide if and how to tell our client's story in the media and what to tell of the story.
So ultimately, though, it's a jury who's making the decision, right? So this is always something that's always sort of fascinated me about, and you've helped us out with some like jury selection and jury consulting and stuff here in this room. And okay, let's assume that a juror truly doesn't know anything about the case, hasn't read any media reports. Don't they just go home and look it up once they get put on the jury?
This is exactly what keeps me up at night, scratching and, rocking myself to sleep, in a panic. Because it's true. Today, there is so much access to information. So it is very important that we ask our judges to admonish jurors, how important it is for them to stay away from the news media while they're serving. Right. And to query them every day. Did you see anything? Did you hear anything? And look, sometimes we just don't know.
Yeah.
We don't know what people aren't honest about telling us.
Yeah. Right.
And it's too easy to walk into a room and oops, the TV's on and oops, I heard something, or I went home and my kid said to me, aren't you sitting on this on this jury? And I heard blood, is that true? And so it's hard for jurors to come in and say, listen, I heard something I shouldn't have heard. But it's so important because, the rules of evidence that exclude certain things protect our clients from prejudice and from evidence that's not reliable. And so when all of that hard work of keeping that evidence is undone by somebody, even unwittingly hearing something that's out there, it can be so destructive to our clients' due process rights.
What are the misconceptions that you have to fight about a client, anybody accused of anything, when they get in front of that jury?
Well, first of all,
it's supposed to be presumed innocent.
Well,
could it be the other way?
That's the thing, right?
Why would you get accused if you didn't do something?
And I think a lot of people walk in with that notion of, we have the FBI, we have our police force, and they've done their job, and they've made an arrest, and the presumption, I think, for a lot of people, notwithstanding our presumption of innocence, is you wouldn't be sitting there unless you did something wrong. I've also heard jurors say, well, if I was accused of something that I didn't do, I would testify on my own behalf. And getting people to understand that there's a reason that people have a right to remain silent is really difficult, right? And it's the job of an attorney to remind people that, sometimes law enforcement gets it wrong. And that
They're human beings that come in with their own prejudices and things too.
100%. And, on top of that, there are a lot of reasons why a person shouldn't testify. First of all, there's always the fear that if a jury doesn't like your client, what if somebody is just nervous and they're not a good speaker and they go blank because they're in a panic? I mean, it's a lot of pressure to testify on your own behalf.
Right.
You're literally fighting for your life. And there are people who are just incapable of doing it and doing it well. And so they can do a lot of harm to themselves simply by virtue of the fact that they can't communicate well.
Yeah.
There are other reasons, like, what if they did something else in their life and that prior crime that has nothing to do with what they're accused of now would come in if they testify? So there are a lot of reasons that people don't testify. It could also open up the door to other evidence that we think is prejudicial, that we want to keep out. And so there are strategy reasons that a person shouldn't take the stand. That has nothing to do with guilt or innocence. So it's really important for folks to understand that. And it's very important, therefore, to do a really good voir dire, which we don't very often get in federal court, unless the judge decides to do somewhat of a voir dire. And some judges do a great job at it. Some judges, I would prefer, if I had an opportunity to question my jury, to tease out those prejudices that they walk into the courtroom with.
Yeah.
But, as communicators, as storytellers, we lawyers have those opportunities during opening and closing to speak to our jury, and hopefully explain to them why, our client was entitled to that presumption of innocence and the government did not sustain its burden of proof.
Right. So let me go back to something you said there about the judges and the jury selection process. So does it vary that much, judge to judge?
Oh, yeah.
Yeah. So
Oh, yeah.
just expand on that a little bit.
So some judges will, well, especially in federal court. In state court, we get voir dire. So, how much leeway we get will vary judge to judge, but we do get voir dire in state court. And voir dire, for those who don't know, it's jury selection. It's where we get to question jurors. Can you be fair and impartial? Do you believe that if a person doesn't testify, that they must be guilty? Why do you think that? Can you understand why a person, after I've spoken to you, might not testify? Can you put aside that belief that they should, and not hold it against my client? These are important things. It's also an opportunity to find out, have you had experiences in your life that might bias you against my client? Or in this type of case, maybe it's not appropriate for you. For example, just a glaring example, were you the victim of a crime? And so, can you be fair and impartial looking at my client?
Yeah. Right.
Important
questions.
Questions. And in federal court, a lot of judges don't give the attorneys an opportunity to do that voir dire. They do it themselves. And some do a more limited voir dire, some do a more expansive voir dire. But that can really change how much information you have about your jurors so that you can say, you're not an appropriate juror for this case, and strike them from the jury.
Right.
And we don't select jurors, right? It's not like we sit there and we go, you. It's actually deselection. We remove jurors.
Yeah.
And one of the things that we lawyers do, and I've done that here, is we do focus groups.
Yep.
So that we can understand trends. What kinds of people tend to be more open-minded in these kinds of cases? What experiences might prejudice people against this kind of a case?
Yeah.
What are we looking for in our jurors?
Yeah. And those kind of hot button issues, you can test those things.
Exactly.
Right. You can, talk about, if it's a gun case or whatever the case is, you can, press those buttons and see how people react to them.
100%.
Yeah.
So focus groups, when we have the resources for them, are just an integral part of the jury process, right?
Yeah. So I want to talk about a case that, it's it's local. It started out local to us, which is the Jeffrey Epstein case. And this case is obviously like, it's been a topic of discussion, certainly here locally for 18 years now, I think, something
Right.
like that. And obviously it's caught the national spotlight. It's part of, all kinds of discussions, the government, Congress, to the point that my son, who just graduated high school, they started looking for names of people they knew in the Epstein files.
Wow.
My name's in there because I was a videographer on one of his depositions back in. Okay. So
my name is in there as well.
You're in the
because I
Epstein
represented
files. I'm like,
somebody, yeah.
Okay, for what?
Yeah, in the civil
like,
litigation
makes
that
sense.
surrounded
It makes sense, right? So all the attention that case has brought, have you seen it change anything about how either prosecutors approach cases, or has that case changed the way that law is being practiced and the way people are thinking about it?
So I think that's such an interesting question. I think that law enforcement, well, let me say this as a starting matter. I think that crimes against children and crimes against women are treated differently than they were many years ago. It used to be a real thing that, like, for example, it was hard to prosecute a rape case against somebody who worked as a call girl, right? Or who might have had many sexual partners. And that has been changing outside of the Epstein case anyway.
Yeah.
But I think that law enforcement now probably listens to women and children victims more carefully. There's an understanding that people in power in the past might have wielded that power and influence. And I think that law enforcement is now more vigilant against allowing power and influence to affect their charging decisions and the manner in which cases are handled.
Yeah.
There is a sense of accountability with powerful people. I mean, look at all of the big corporate executives, famous people, powerful and influential people who have been pulled into the inquiry here about what exactly happened, because these were all people who interfaced with this person. There is a sense now that powerful people need to be on their toes and use that power appropriately. Right. I feel it.
People are paying more attention.
People are paying more attention. I feel that. Has it changed the jury system at all? No, I don't think so. But certainly I think that law enforcement is very careful not to let the perception of power and influence to sort of creep into the charging decision. Yeah. I do think that that's a change that has occurred.
Yeah. You mentioned earlier healthcare. And then we have another client who has had some big healthcare defense cases and things like that. Why has that become, in your opinion, either something that the government's looking at more closely? What's happened with healthcare? What's going on with the prosecution of people in the healthcare industry?
Well, first of all, healthcare is something that affects all of us profoundly.
Right.
So it's important just community-wide. It affects everyone. And of course, there's a big concern that Medicare may run out of money. There's a huge drive to prevent fraud, waste, and abuse in the government generally.
Right.
And of course, the Medicare system is a huge target for that. Yeah. Right? We spend so much money supporting our healthcare system. And so just the notion of fraud, waste, and abuse in that system is so offensive to people. Right? And it affects all of us. Right. So that is a natural place for law enforcement to focus. And I will say this, it is such a heavy regulated area of the law and of our community and our world. It is a very difficult system for healthcare providers to navigate. The rules are just intense, for lack of a better, they're complex.
Yeah.
And very often healthcare providers and people who work in the healthcare system don't consult lawyers early enough, and they get into trouble. And I'll give you an interesting example. For example, sales. If I were a shoe salesman, I could get a commission for every shoe that I sell.
Right.
But in healthcare, if you're a marketer, and there are exceptions to this, but generally, unless you're working in-house for a company, you can't get a percentage off of your sales. And so a lot of marketers are easy targets for law enforcement. And the rationale for that makes sense, right? You don't want bonus or commission or kickbacks, so to speak, to drive healthcare referrals, and to drive unnecessary medical expenditure, right?
Right.
But so many people who are coming to sales in healthcare from other types of sales don't know that. And it's very easy for them to get into trouble.
Yeah.
And I could go on with various examples of that, of things that aren't necessarily intuitive, but they make sense once you start thinking about, why do we have that regulation?
Yeah.
But it's very easy for somebody to violate healthcare regulations.
Okay. So when you talk about sales, I mean, is that equipment? Is that
all of it?
Yeah. Okay.
From
so everything.
from labs to equipment to even just doctors advertising their services. So, for example, like specialty providers providing kickbacks to non-specialty providers. We saw that in the Melgen case some years ago. Again, this is a very simple, straightforward regulation, or at least it seems that way. But then it gets complex because there are exceptions to that.
Right.
And do you fit within one of those exceptions? And this is why I say to people, go to a healthcare lawyer if you're in the healthcare industry, because you really, an ounce of prevention and a compliance review can save you real headaches.
Yeah.
It can prevent you from having to call me.
There we go. So I want to talk just on your career overall. Who are some of your mentors, the people that helped you out, and what were the big lessons that they learned that you could, pass on to our audience?
So I have led such a blessed career. I've had the greatest mentors in the world. From the very beginning of my career, where all of the very successful, brilliant criminal defense lawyers there embraced me. I literally was like, we'll do a hearing for lunch, we'll write a brief for dinner. And they all kind of took me in and embraced me and taught me and allowed me to participate in hearings and second chair them. And then when I moved to Florida, of course, I worked for Richard Lubin, who is still to this day family.
Yeah.
And he allowed me to spread my wings and handle the hearings, handle the briefing, handle the arguments, take witnesses during trials. He allowed me to grow and blossom. And, I work extensively with Doug Duncan, who's a brilliant criminal defense lawyer, Scott Richardson. I can go on and on and on.
Yeah.
And I will say this, the mentoring system is irreplaceable, right? And a lot of criminal defense lawyers don't work for a big firm where they have mentoring sort of institutionalized, right?
Yeah.
And if you don't work for a public defender's office or first start at the state attorney's office, then you don't have the advantage of all of those mentors, right? So the criminal defense community is so unique in that we mentor young lawyers. We have them cover hearings for us, or, sometimes I don't have time to write this brief. Can you write this for me?
Yeah.
So it's wonderful.
Yeah.
And the thing that they taught me, and the thing that having all these different mentors taught me, which is such an important lesson for young lawyers, is everybody has a different style. Everybody has a different voice. Everybody has a different approach before a jury, with prosecutors, with clients. And it's really important to develop your own voice.
Yeah, that authenticity.
Because you're a communicator. And if you're trying to imitate this guy or this woman, you're never going to be true to yourself and you're not going to communicate effectively. There's going to always be a dissonance, right? And you have to be speaking your truth. That's how you win cases.
Yeah.
The jury has to believe and trust you. And if you're not using your authentic voice, they can't.
Yeah, that makes a lot of sense. So where can our viewers get in touch with you? Where do they find you? They want to talk to you about a case or just get your advice on something, whatever.
So they can, of course, go to our website and, all of my information is there. It's KTAP, so ktap.com.
Okay. KTAP.
KTAP.
Yeah.
Or kudmanlaw.com. Both domains work.
Okay.
Or they can call me at 561-472-0811.
Okay.
And, they'll get to me. And I have an incredible associate who I can't say enough about. He's also part of the team, and my paralegal, Nisa Nardi. All of us are available to help you and speak with you.
All right. Well, Tama, thank you so much for joining us. I really appreciate the time.
Thank you. I love being here.
Awesome. Thank you.
If you'd like to appear on Courtside Convo, send us an email or visit us at legalgraphicworks.com. Look for new episodes every Thursday on the Legal Graphic Works YouTube channel, and don't forget to like and subscribe so you never miss a show. Thanks for watching.